It is 9 o'clock, so we will go ahead and get started promptly as we said we would. My name is Laura Klossner. I'm a criminal defense attorney with Peterson Law Group, and I'm currently the secretary for the Volusia Flagler Association of Women Lawyers, or VFAL. This CLE this morning, Technology in the Clerk's Office, is being co-sponsored by VFAL and the Volusia County Bar Association. And it is going to be presented to you by the perfect person to do that, which is our own Volusia County Clerk of Courts, Laura Roth, who is a very active member in both VFAL and VCBA. You may not know that Laura does have both her bachelor's degree and her law degree. Not all clerks do. And as I said, she's an active member of both. She's a very active member in lots of professional organizations. And you may not know it, but she was actually selected as the Clerk of the Year in 2021 by the Florida Court Clerks and Comptrollers Association. She may not have gotten all of those accolades since seem to all be still on Zoom in 2021. So without further ado, I'll let Laura take over. The CLE is an hour and a half long, so you will be able to get up to 1.5 credits of both general CLE and tech CLE. So go ahead. Thanks for hosting us.
Oh, you're so welcome. And we really appreciate having you all here. Thank you to everybody attending. I just wanted to say I was a little shocked for a moment there when you said that. So it is an hour and a half long that we have this CLE. I think we were told a different time frame. So that's actually good. We can adjust. But is that
the CLE credit is for up to an hour and a half, but if it needs to be adjusted, it can be adjusted.
That's okay. I think we can do that, guys. Don't you think? Yeah. Okay. We can adjust ourselves accordingly. We were told originally it was even longer than that. And we actually were a little worried we might have to really get down into some weeds to fill up that time. So an hour and a half is great. Okay. Let me just pull up my notes. So thank you for the introduction. And I am Laura Roth, the Clerk of Court. I want to thank the organizers, especially for this. This is such a neat idea. We were honored to be asked to hold this get together. So I want to thank VFAL and the VCBA. I also believe the Paralegals Association and the New Volusia Paralegals Association may have also circulated it. In fact, we'll kind of do a poll of who's on the call here in a minute. But first, let me go ahead and introduce my two co-presenters. And they're just wonderful and skilled people that have a lot of experience in clerk world generally and specifically technology, whether that's through actual technology of one of our speakers or whether that's through rules committees, which you will soon learn really affects technology concerning the courts, clerks, and yourselves as practicing attorneys. So first we have David Isaacson, and you'll see him on the screen there. And he is our Chief Information Officer here at the clerk's office. A little bit about him. He earned a Bachelor of Science degree in accounting and a Master of Accounting degree from University of Florida. But he is our CIO and is not acting with it in his capacity with his accounting degrees. He currently sits on the FCTC. You'll learn who that is in this presentation today. It stands for the Florida Courts Technology Commission. Very important group concerning clerk technology and court technology. So he does sit on the FCTC's Case Management System Standards Committee subcommittee, and he's an active member of many Clerk Association work groups, our statewide association. So he's on the Clerk Technology Group, the Clerk UCR workshop, which you're going to learn what that means, the CCIS, another one you'll be hearing what that is, the CCIS Data Quality Work Group, CJDT Data Quality Work Group. And he was on the team that won the 2015 Best of NEAM Award, which we were very honored to receive at the clerk's office. So there's no better mind in the tech world than David Isaacson. We're very happy to have him with the office and have him here today to speak to you all. Secondly, I have Mr. Hymas. Now, I want to say as a special introduction for him, if any of you have dealt with Mr. Hymas, he's our Chief Legal Officer here at the clerk's office. And let today be instructive for you that it's not Mr. James or Mr. Jamies. So we know it's a little unusual of a spelling of a name for most of you, but it actually is pronounced Hymas. And he earned his bachelor's degree from the University of Central Florida and his JD from FAMU College of Law. Prior to joining the clerk of courts, our office, he was an assistant state attorney for the state attorney's office here in the 7th Judicial Circuit for R.J. Larissa before I persuaded him to come and work here when I transitioned. I used to be the in-house counsel and the chief deputy clerk for the former clerk. And so I was in his position prior as the attorney for the organization. And so when I became clerk, I persuaded Mr. Hymas to come and take on that role so I could shift focus. So Mr. Hymas serves as a committee member to another group you are going to hear a lot about today, the Rules of General Practice and Judicial Administration Committee. That name kind of frustrates all of us. They used to just be called the RJA, the Rules of Judicial Administration, but they realized that caused a lot of attorneys to skip past that rule set, thinking it only applied to the judiciary. And unfortunately, it does not. So they changed the name to the RGPJA, which is quite a mouthful. But he is a member of that committee, a very, very important rules committee. So we're proud that he got that position. He's a chair of a subcommittee for that committee, and he's a liaison to the Florida Probate Rules Committee as well, where he's also the chair of a subcommittee. So I'm so glad the two of them could join us today. I'll drive most of the presentation, but they will break off and speak on some of the slides. Really quickly, now that I think you've gotten to know us a little better, here's where I was asking David, I don't remember if I got a message back from you. Is it possible to pull down the slide for a moment so I could ask some questions and see them? Okay. So we're going to drop the slideshow for just a moment because I wanted to get a little bit better sense in a participant poll. If you guys are on devices where you can do hand raising, I'd really appreciate if you'd participate in a few questions. A lot of people were invited to this call, so I want to just make sure who our audience mainly is, so we make sure we're addressing things in the most beneficial way. So would you please do your electronic hand if you're able to do that? If not, physical hand if you're on camera is fine. But would you raise an electronic hand if you are an attorney? Some of you knew that's what I was going to ask, didn't you? Because I saw some hands come up. So how many actual attorneys do we have? I'm having to scroll through because you guys are at the top of my screen. I don't know what your view looks like. Okay, so keep them up, please. Okay.
As a counter, you're at 11 right now. At
Okay.
12.
Thank you, because you're probably seeing a better view than I am. Okay, thank you. That's really instructive. Oh, off to the right is much easier to see. Great. Okay, so that's how many are actual attorneys. Okay, if you guys don't, thank you and appreciate you joining us. I know you have busy schedules. If you don't mind putting your hands down, let me ask, how many of our guests today on this call are paralegals? Or you're working in the law firm in some capacity, not an actual Florida Bar admitted attorney, but you work at a law firm helping process those cases. Okay, excellent. Okay, great. So we have a good number, about the same number of you all. Okay, I'm so glad to see that because we were hoping it would be a nice mix. I know that, you know, paralegals do an awful lot on behalf of attorneys and are often the ones that are interfacing with our office. So I am trying to be an active participant in the new Volusia Paralegals Association for that reason. Okay, thank you all. And you could lower your hand. That means we have quite a few people that are neither. How many of you are on the call just to learn more in general and you're neither an attorney nor do you work in the legal practice? Who's just joining for information? Okay. Well, thank you. Okay. Well, I appreciate that. And if you want to go ahead and put our slide back up, I just wanted to get a sense of who's here and I'm glad to see it's a nice mix of people. Okay, so we'll start with an overview about what we're going to talk about today. I'm going to need to be conscious of time since we do have less than I thought, but that's probably an okay thing. So David, if you could go to our first overview slide. Okay, so what we're going to be discussing today are several topics that will weave into technology. So you may even have moments in today's presentation where you're like, how did we end up talking about, let's say, this rule about how you're supposed to keep confidential information out of court filings? But I promise you, no matter where we're headed. And if it seems like we're on a rabbit trail, we'll wrap back into technology. So we're going to go over major systems that clerks and courts, we're kind of interchangeable. Clerks are the custodian of the record for the clerk. So our systems affect their systems, etc. So major systems and differences concerning court technology, maybe more broadly, including clerk. Tech and current court rules. Like I said, a lot of court rules, your rules that you're supposed to follow do involve tech and technology-based instruction. Technology and accessibility, meaning at what point when people are having accessibility issues, does technology sometimes solve the problem or play a role? And then we're going to talk about there are some pending technology related court rules. So we want you to be aware, and we'll give you some highlights of these pending rules that are still open for comment that are again going to affect how you all and ourselves use technology in the courts. We also will talk about e-filing transitions and e-filing common issues, because e-filing being one of the main technology avenues used for you all to communicate with the clerk's offices and the clerks and the courts. Okay, so then we're going to stop for a Q&A there. We did want to say as a housekeeping measure, we thought it might be easiest since we'd rather just get through all the pieces in each part before we open up for Q&A. If you're comfortable submitting comments through the chat, please feel free. Oh, somebody said they're an investigator. Thanks for letting me know. Please feel free to use the chat as we're going. If a question crosses your mind, you want to preserve it for the Q&A, and that would help us somewhat pre-prepare for what's going to happen at Q&A. So please feel free to write your questions in the chat. We will not stop and read each one, but when we get to the Q&A, we'll look at your questions. Okay, then in part two, we'll see what time it is. We have a little break there. And then part two, we're going to talk about Supreme Court impacts on clerk tech. We're going to talk about the technology commissions and committees. Several of I've named already. There ends up being a lot of C's and F's and FCTC, CCISs. You're going to get really sick of hearing FC's and T's. We're going to talk about the security matrix, which governs access to court records through the state of Florida. Okay, and we can tell by some of the orders we get that people are not aware of the security matrix. So we're going to teach you a little bit more about how that works and how strict that thing is. Then we have court reporting requirements. That's SRS to UCR, more letters for you to learn about today. These are things that drive a lot and take up a lot of clerk technology related resources, time and effort, because we get a lot of mandates coming down related to case reporting. And then other court driven technology impacts, like UCM. We're going to give you an example of a change that the court made that impacts technology through all clerks' offices. The statewide system, CCIS. And then we'll talk about our local clerk IT projects here at the Volusia County Clerk's Office and our portfolio board and how we prioritize those. And then we'll have a last Q&A, okay? So if it sounds good, we'll go ahead and get started. Okay, I'm going to talk a little bit about this first one. There are several systems, and I think just as a base, it would be helpful if we just mentioned and explained, okay, that there are several systems interacting in different ways that make up the technology that underlies the courts and the clerk's offices. So one, most of you should be familiar with that are attorneys and or paralegals. You're probably familiar with the statewide e-portal. Most of you have experience e-filing something on the e-portal. So that's a statewide system. That's board, it's called the e-filing authority, is made up largely of clerks, but there are other members, but that is a statewide system, not a local one. We also have the local comprehensive case management system. And that's when you guys log into clerk.org. Do people log into clerk.org and look up your case, look up different cases, see what documents you can see online? You're looking at our local comprehensive case management system that is specific to the Volusia County Clerk's Office, and it is limited to Volusia County court records. Then you have at play, and you've probably never interacted with this, but I want you to be aware of it. Then there's also a judicial system. So they used to just directly use our same case management system in court to pull up once records went electronic. They used to just use our own case management system directly, the clerks, to look at documents. But as we've developed more sophisticated capabilities like electronic orders, e-signing, It was a state movement to have judges have their own viewers because clerks and judges' needs might be different. So all of the different circuits have adopted some form, different vendors, but some judicial viewer, which overlays on top of our system and pulls the data they would need. So often judges are not looking at the same system that you would be when you look at your clerk system to look at your case files. So the judicial viewer here in Volusia County and the 7th Judicial Circuit is called Benchmark, okay? So Benchmark sits on top of the CCMS. And then we have CCIS, which you all as attorneys and paralegals right now do not have access to. Only government attorneys, if there are any on the calls, anybody on this Zoom, if you wanted to raise your hand and admit it, already have CCIS access because you work for a government agency. So you are able to get on the statewide system that pulls all court records from around the state. Anybody have access to CCIS? Raise your hand. Just be interesting to see. Okay, looks like we don't have anybody here that has that, but we'll be sharing with you where that's headed. Okay, so one of the first distinctions I wanted to draw for everybody is that the statewide filing vehicle is the e-portal. The difference between that and our local official case file. So the statewide filing vehicle is, like we said, the Florida court's e-filing, but it is a delivery system. It is a statewide way to submit documents and to get them to the appropriate clerk's office to then be processed and added to their local case management system. The official court record, the official case file, what we used to call originals, right, before the electronic world, is in your local clerk's case management system. The e-portal is not a case management system. Now, some of you may say, yeah, but I can see images from the case and other documents in it right there through the e-portal. The e-portal is pulling that information from local clerk's offices and replicating it for you just for convenience, okay, through CCIS, the statewide system. So I just wanted you all to know those are two totally different things. And when you're looking at what's officially in your court file, that is not the portal. Go to our local clerk.org, go to your CCMS, and that's your official court file, okay? So one of the reasons to know that is we do often get confusion where people think that we can locally control the email addresses from which you're being served from the portal. So I want to make it clear. The local clerk does not control your email addresses at the e-portal level. Hopefully most of you have gotten used to that. The local clerk cannot add or remove you from a case on the e-portal. So you don't contact us to say, I don't want to be in this case anymore. I've left it. I don't want served in this anymore. Because as long as you can also have an email address in our system, that can happen. But if you are still on the e-service list on the e-portal, that's what's getting you served with those documents. So just to be clear on that, if you added yourself, you must remove yourself at the e-portal level. You'll be served how it works here in Volusia County. And this is not every county. I know there are differences between counties. It is what it is, different judicial needs. Here in Volusia, we were asked by the judiciary to e-serve for them all judicial orders. And we also e-serve clerk generated notices and documents. So you get e-service from our local CCMS here in Volusia at your email addresses from where? Email addresses that you've used on the statewide e-portal. Okay, so maybe if I gave it to you for a minute to talk about that, David, about how does that work? If we're going to e-serve an order from a judge here in Volusia County, how does that go?
Right. We have a communications link to the portal. The portal offers to any county that wants to use it. But we are able to ask the portal what are all the e-service addresses that have been entered that the portal would also serve to, so that we are unified on some of that. And that's actually what the local AO requires us to do is to use what is on the portal. Now we went a little bit further because of course then the needs have changed in years. There are also, pro ses that need to get served that aren't going to be on the portal. So we do also have to combine that portal data with some of our local data as well to come up with a local service list. But the primary method is from the portal. So if you haven't removed yourself from the portal, you're not only going to get served from the portal, but also from us eventually as well.
Absolutely. So hopefully you all could follow that. You will be served at both. So you will be served at both emails on the e-portal and any that we have in the local CCMS. Okay, so that is how that works. Now, unfortunately, and maybe they just weren't aware of this, and I hope it wasn't intentional on their part, but we have had recently some attorneys tell a judge that because our office had not added them to the case yet here at the local level, that therefore they were not e-served with an order from the judge. And that's absolutely untrue because we pull the email addresses from the portal. So because that attorney had filed through the e-portal when they filed their motion, they certainly were served with the order. And we do have a tab that shows that's available to us and to all court clerks. And Judge Case is going to help us educate all of the judges to this as well, that there is that data available at their fingertips right there in the courtroom, who exactly was served. Okay, so please don't try the argument that you weren't served because the clerk hadn't gotten me added to the local CCMS yet. That is just not true. We're going to e-serve you one way or the other. Okay, so just letting you know, and I hope you're not on the call, or if you are, please don't be offended. Okay, so the other thing to remember is just that the portal is not a case management system. It's not holding the documents filed. It's not docketing them into the local cases for the judges to view. It is just a conduit and a delivery system to the local CCMS, and that's where the official case file resides. If then also CCMS is where filings are docketed into the official court file, and this is where you should view court files for the most comprehensive view. Okay, so next slide. Okay, so the next thing we wanted to talk to you about is a very important group that we feel, from our experience over the years, it becomes apparent to us. I know it may not seem like the most interesting group. A lot of you are in really incredibly compelling areas of law and practice to where you have much bigger things to worry about than the procedure and the process and the technology that underlies all this. Unfortunately, in our view, the types of things, the types of rules and the impacts to you all and to us that get passed through this committee, we really feel like we wish more people were involved in paying attention, particularly attorneys. We wish that more of you were involved in keeping track of what goes on with the RGPJA. So we say, who are they and why should I care? I believe we were going to real quickly go to a link on that. So we have a link in this presentation. I would imagine we could share this out later if some of you would like to click through any of these links. But this takes you to their page, the Rules of General Practice and Judicial Administration Committee, and look at the makeup of this. So you've got all kinds of representatives. There are attorneys from around the state, of course, as they are on most rules committees. But this is a big, powerful group. There's Antonio Jaimes, our own Antonio Jaimes, who's a member. So these people come together and make rules that affect you. We could go back to the slide. So they are where promulgate a lot of the technology mandates that go on affecting court records through the court rules. So for example, in 2.5 rule 2.5125, you have e-signatures dealt with, e-service is dealt with in 2.516, 2.525 is e-filing, 2.420, we're going to get into more, is about confidentiality and redaction, and that arose because of electronic records. That did not exist before records went electronic and the courts were faced with decisions, access versus privacy. So they developed Rule 2.420, which is what you're supposed to follow to give assurance that inappropriate information won't be public. And then one of my very favorites, 2.425. That is the minimization rule, and it is an absolute mandate on attorneys to follow. And it's not to pick on you all, but we find it is often not followed. And I think it's a very misunderstood and unknown rule that I wish I could sit down with every attorney at a nice lunch and go through and talk about. Because if we had everybody complying with that, we wouldn't have some of the access problems that we face. Okay. So if we go on to the next slide. So now I'm going to turn it over to Antonio Jaimes to talk for a while, because he's going to do a bit of a deeper dive into 2.420. And you'll see as this goes, this is one of those moments you're going to go, why are we talking about this? This doesn't seem like technology, but it will loop back into technology. Okay. So Antonio, take it away.
Yeah, thank you, Laura. And, just to, talk a little bit more about I call it the RJ. And as Laura mentioned, it got changed because it was missed a lot. People thought it was only rules for the judges, but in fact, these rules, if you haven't looked at them, please get familiarized with them, because it's got a lot of important information. It talks about, what we actually do in practice, but we don't realize that there's a rule for it. For instance, how do you come into a case? By filing a notice of appearance, by, showing up in court. How do you withdraw from the case? What's needed in a motion to withdraw? All of those things can be found on the RJA. And although everyone has their own unique practice, criminal law, practice law, and you refer to those rules, these rules actually bleed into those rules. And these are the practical ones that every practitioner should be aware of. So if you haven't gotten a chance to go in there and look at these rules, please do so, because they're very important and they get modified almost every year. I sit in this committee and, we meet 4 times a year and we get referrals from different people across the state. And also, I'll make the invitation as well that if you're interested in serving as a member in all these different rule committees, that's also available. So please look at these rules. But for our purposes, I want to talk about 2.420 because that's actually what controls what actually is very important for the technological aspect that we're going to discuss today. So if you're not familiar with 2.420, if I were to pick one rule out of all these rule subsets for our purposes, please look at Rule 2.420 because this is the one that governs public access and protection of the judicial branch records. So the rule basically outlines and defines what court records are and who these records belong to. These records belong to the judiciary, but the clerk's office acts as an arm. So we're the ones who protect and hold these records for the judges. So it's on us to protect the confidentiality of these records, and is why this rule is very long. It's, I believe, 6 or 7 pages long, but it actually spells out all the different things dealing with the confidentiality of the records. And by the way, Laura was a pioneer in developing this rule. So Laura, if I missed something, I know you know this rule probably better than I do, so feel free to chime in. So what I want to hone in is the list of 25. So under 2.420, which is subsection D, it provides that the clerk shall maintain these records confidential. So it goes on and provides the list of what now, I believe it started with the list of 19, if I'm not mistaken. And then throughout the years, items get added into the list. And what happens is that every year when the legislature meets, they carve out all these different confidentiality and court records. But it's clear that there's case law that states that although the legislature can come out with protections of confidentiality information in court records, they cannot mandate the courts to protect those records because the records belong to the courts. And there's case law specifically that says that legislature, you can, bring out all these different legislations mandating us to protect these records, but unless it's in this list, we're not going to protect it unless it's added to the list or you file a motion under this same rule. So the list here, which is David's showing it, it's gotten to 25, and these are records that are readily identifiable. Our staff is trained to look for these records. So we're, whenever something's filed within the court records, and I'll get into the changes because I just want to give an overview of what we've been currently doing pre-2021 as to what's changed post-2021. So whenever you file a document through the e-portal, it gets sent to us. We have people who review these documents and look for, the readily identifiable information, such as a social security number, such as victim names, for example. Anything that's in that list of 25, we go in there and we look for that information. However, under the current rule, you're supposed to file a notice of confidentiality within a court filing. A lot of people were not doing it. So, but we still went ahead and protected this information because it was something that was required from the clerk. Now, in 2021, there was a Supreme Court order. And before I get into to this order, Laura, if you want to give a history as to why we got to this, why the Supreme Court order was entered by the court.
Yeah, I just wanted to let everybody know that as this went on, we are very, because we're so affected by these rules, you guys, I want you to have the assurance that we are extremely active in these rules committees and that we watch this kind of thing and we advocate. And we generally advocate from a couple perspectives, one being ultimate access. Our mission here at the clerk's office is to make accurate information accessible to all. So we believe in broad public records access, and we advocate for protection of private information in court filings, even when that means that we are catching things on the back end to support attorneys and not let inappropriate information get out. So we advocated vigorously for over a year as this debate went on. We were on calls every single week for literally over a year and used all of our negotiating power at the state level to try to combat this rule that he's getting ready to tell you changed. They removed the clerk from some of those duties. And I just wanted you all to know we put in a tremendous effort and just lost that battle. It was started by the Media Coalition. I know you might go into more of the case, how it evolved, AJ.
Yeah. So prior to 2021, as Laura mentioned, we were advocates protecting information, but also giving you the public access that that everyone's entitled to under the Constitution. But in 2021, after the Media Coalition started complaining, the Supreme Court came out with this order here, which basically eliminated the requirement from us to independently designate the confidential information in civil cases. All right, this only pertains to civil, circuit civil, county civil, and small claims. This does not affect criminal, probate, guardianship, and all the other case types. But in this particular order, we can no longer, and David, you want to go to the next slide? So this is part of the order, which basically states that we can no longer automatically protect that information. So if you want something protected, you must file a notice of confidentiality within a court filing, because if you don't do so, guess what? That information is not going to be protected, and it's going to be out in the public website, which has been created at the portal level, and we'll get into that in a few minutes. But you must file that notice or file a motion to determine something confidential, which is also under Rule 2.420. And that's why I highlight and emphasize that look at this rule, because if it's not an item under that list, you have to file a motion. Otherwise, it will not get the protection that you think it should require. So here, this is the order came out and say that you must file a notice of confidentiality within a court record or file a motion to get that information protected. David, you want to go on to the next one? Oh, and also in that same order, they emphasize that it's upon the filer, which is you. You're the sole responsible party to ensure that you protect that information, because if you don't, there can be sanctions under this same rule. So that's a way that they're using, the courts are using to hone down on and ensure that you guys are following the notices or the motions. And here under this same rule, again, it just reiterates that there has to be a notice of confidential information within a court filing, which we have one. If you go on our website, we have a form that actually puts out the information. There it is. And it basically dictates whether if it's the whole document that needs to be protected or whether there's certain parts of the information. So when we get this notice at the clerk's office, we'll look at it and we'll verify and compare it to the list of 25. If what you're asking to be protected is not within the list of 25, you will get a notice from our office giving you 10 days to file a motion, because if you don't do so within those 10 days, that information is going to be released to the public. Now, if you do file a motion under 2.420, then we'll protect that information until there's a court order telling us whether to keep on protecting it or releasing it to the public. And also a little bit more on these motions. These motions, again, are found under 2.420, and there's a subsection for either criminal or non-criminal. And it outlays what exactly what needs to be in the motion, and also provides what an order requires, because as from our perspective, some of these orders have to be put on the website. So we need to be told that specific information, and we need to be told other things. I'm not sure, David, what other things we need.
I believe that well, and I think it's part of this notice of confidentiality. The filer is supposed to actually identify which docket it is, where it is on it. It's not supposed to be a general, hey, find everything, for the clerk. We are supposed to be directed to exactly where it is that the confidential information can be found.
Right, and that's important, because when we get these orders, we'll receive and post, we'll get these orders and we'll look at them, and I'm having to find myself going into court and clarify what's needed, because from a technological standpoint, there's limited things that we can do. And if you give us a blanket order, for example, we can show just attorney A, but not attorney B. Guess what? We cannot hand select what attorneys can see a document and cannot. So it's very important that you look at this rule, because this rule was meant to help the clerk's office so we can, so we're able to show that information to the public. Laura, you got anything? I don't know.
One other thing I was going to add, and at the same time, part of the fallout of this that you have probably noticed when you're filing is this led to the changes on civil filings when you're creating, when you're filing in civil, where you have to actually pick, is this does this contain, you know, any confidential information? Is it non-confidential for every single thing you file now? Because that then flows down to the clerk. So that's what led to those changes in July 2021 on the portal.
Correct, which we'll get into that, because at the portal level, as you mentioned, David, there's series 3 buttons, I believe. And Laura, do you want to talk about that a little bit more?
Yeah, they just, you know, basically in a nutshell, what happened here, you guys, is, because I know this is a lot, but what happened here is, it used to be if you failed to file your notices of confidential information, that there was a safety net for you. And we have really gotten very good. Those are readily identifiable things, that list of 25. That's why they narrow it to those, because we can't find a needle in a haystack. But these are things we've generally been able to find with relative ease from our experience and catch them. And we'll show you some statistics of how often attorneys do not file the notice of confidential information, and we end up redacting anyway, because we were your safety net. The problem is they changed the rule above clerk objection that in civil cases, except for a few exceptions, most civil cases, we are not allowed to serve as that safety net any longer. So if you've included information that is confidential, is not supposed to be in the court file, the clerk's hands are tied to protect it. And that's where it leads back to technology, because at first they tried tweaking the rule. And you saw that language Mr. Hymas showed you guys. It said the clerk is no longer required to maintain or designate. Well, as you can imagine, let me just give them the history of this now. As you can imagine, a lot of clerks, I'd probably say half or more, read that language and said, well, you just said I don't have to, but I believe I serve my constituents. I help protect the, you know, public against information being disclosed. So I'm going to continue to anyway. But as we said, it was the media coalition that was demanding this change. Now, why? Because they believed if the clerk was removed from the redaction role, that all filings in civil would be automatically accessible the second they were filed through the e-portal. They'd just appear on all clerk websites and be public information right away, no delay, no 2 seconds to open the mail. They would just appear on clerk websites instantaneously. As I said, the court worded it such, though, that we just didn't have to redact, not that they prevented us from it. So a lot of clerks continued to redact. Therefore, the media took it a step further. They realized that the rule kind of hadn't worked. It didn't make access immediate. By the way, there are other processes we have to do to documents besides redact them, so it's never going to be immediate. But however, they kept believing if we could just make them stop redacting, we'll get these documents so much faster. So they then took us to court over it. Do you remember that procedural posture? Just briefly, Antonio, how that went
Yes.
down in court?
Yes. So what happened is that once the media realized that they weren't going to get their instant access, what they did is they filed a federal lawsuit against one clerk, I believe it was Broward clerk, and against the portal authority. And the federal court first granted a preliminary injunction ordering that there has to be some sort of plan to provide that access. So after a series of filings and mediation, there was an agreement whereby there would be a state system that would give filings, at least the civil filings, not, remember, this is only civil, does not impact criminal, guardianship, and other court practice, because those do have tend to have a lot more confidential information. So they developed this filing access on the portal, which now when you file a document, if you don't file that notice of confidentiality with it, or if you don't file a motion, guess what? That file is automatically being shown on the portal level. So if you fail to do so, you may be showing social security numbers or other confidential information, which could land you in some hot water, in my opinion. So we'll go ahead and show you what this actual portal looks like.
Yeah. We want you to see it's actually happening. I don't think most of you are aware that this is happening. Do we have a lot of civil practitioners on the call? I hope this is catching your attention. I know it can be easy to zone out these presentations, but please watch this part.
So,
Okay.
so this is something that is available to all filers on the portal once they've signed in. After you've signed in and you get your portal map to go into filings, in the top left corner is this filings access, and this is the new piece that Antonio was referring to. And when you click on that, this is a live view. You can search by date. You can sort it and filter to only specific counties if you want, or see the entire state at once. You can see, okay, I only want small claims or I only want county civil. But right now, this is a view of what it looked like on the date I took this screenshot on the 5th, and these are live access, and I could keep scrolling and scrolling and scrolling and see every single document that was filed in civil court in every county.
Yeah, so are you guys grasping that impact? There is an actual live site where these documents have not been looked at by anyone. So
right,
let's say accidentally in a civil case, you say on the docket, you pick the docket, what did they pick here? Complaint, petition, civil cover sheet. Let's say you picked that, but accidentally attached a forensic report of a minor who was sexually molested. Is it going to go live on this website to the entire world? Yes.
Being shown access?
No
Do you actually show them?
yeah,
It
and
actually, yeah, we can actually see this. That now all it does that's different than the document that would end up showing on a clerk's website is it has a stamp that says not an official court document, but you can still read the entire document. So he's now taking you to the live site, you guys.
so this is live right now, and you can see
Right
there's just
now.
pages and pages and pages of them, and this is
Right
every
now,
filing.
this moment, you can see that there was, it doesn't even tell you what it is because it hasn't been docketed yet. Really, it just says the case style.
It's whatever the attorney picks on the portal.
Yeah, it's
But yeah,
whatever you picked. It'll say, look, they filed a complaint, they filed a summons, they filed a this. And these are all going to this site simultaneous. If I'm honest, we even say it gets to them before it gets to the clerk. Now it sends out to both, but let's say it's Friday night at midnight. I'm not funded even to run a 40-hour work week, by the way. We only can pay our people 37.5 hours. Don't let me start on our funding situation. However, I definitely don't have people working 24/7. We are not even close to funded for that. I'd like to get there if I'm honest, but we don't. So if it's filed a Friday night on a midnight, it is out there that whole time before the clerk even gets there and sees that this train wreck happened on Monday morning. So is everybody grasping the gravity of this? I thought about publicizing it to you all more, but if I'm honest, I didn't want to advertise it. So when it happened, they sent out a warning through the Florida bar. I know we find it where they sent language out to everybody or posted it or something. We found the language and they warned all attorneys. There's a live site now. So if you're in civil, you better be filing those notices of confidential information or you're going to have some crazy stuff getting out there. But I don't know who all saw it. And I didn't want to push the point because I was afraid it would attract people with nefarious intent to this site. Okay, go ahead. Sorry about that. So does everybody get, anybody, please write any questions in the chat you have about that. How many people are already aware of this? You guys interested in being interactive? I'd love to get some feedback. How many people already knew that your civil filings are going to a live site where the media or anyone else, it's not restricted to the media. They're the ones that wanted it. Kim knew. Anybody else? Does anybody else was already aware that if you're a civil practitioner, your filings are hitting a live site without any review or protection whatsoever? A paralegal knew that. Okay, good. But I hope that I hope that's one of the reasons we're recording this. Hopefully we can get other people to watch it after. Yeah, she said it's a bad news website. Yeah, it really was. I'm not trying to just, I get along great with Frank Fernandez from the News Journal. I'm not trying to be a media hater. This isn't a political statement, guys, but I'm just saying they were distinctly and openly the ones that pushed for this. They did not want to have to wait. It used to be for us minutes, what could be, however long it would take for us to make sure there was no confidential information. They're unwilling to wait for that anymore. So they solved it with a technology solution. It ended up coming down to the only way we can fix this is that way there's no clerk discretion. I could be protective of you all and the public all day long. It doesn't matter. It's out of my hands. Okay. So please also know that that's not a clerk site. That's just the solution. So let's look real quick. I'm sorry. Am I good, guys? Did I step on you guys' toes? Are you good on that subject? Okay. We wanted to show you real quick how it is working. Okay. As far as how much information is leaking out there. So you'll see before this rule change happened, when clerks used to automatically protect all the 25, even in civil cases, when you all failed to file a notice of confidentiality with the document that had personal information or sensitive information in it. just look real quick from October to December 31st. So you have a good 3-month spread there. There were 39,000 roughly documents filed in circuit civil. Of those 39,000 documents, there were 70 notices of confidentiality filed with any of those documents to say to the clerk, there's something confidential in here, please protect it. How many documents did we actually perform redaction on in that same group? 274. So that means 204 times clerks were the safety net that caught something on the list of 25, which should not have been out there publicly in the court record. And we caught it for the attorney or the filer, the pro se filer, because there was no notice. Now, after that technology solution was sought and obtained by the media so that it goes out there, I have no ability to stop it from being displayed now. Everybody was warned. We were hoping that would improve, that people would file more notices of confidentiality and we'd find less to redact, but unfortunately it has not. If you look at our October 1st, 2023 to December 31st, 2023, this is after the rule change. We're not supposed to be protecting anymore, and they're not protecting on that website. Out of 54,000 documents filed in circuit civil, anybody notice we're a lot busier, by the way? Look at these numbers. 54,000 documents filed in circuit civil. There were only 61, there were even fewer notices of confidentiality filed. And we redacted even more of them with the safety net, 319. Now you may be scratching your head going, well, you just told us you're not supposed to protect it anymore. So why did you still redact 319 documents if we only did 61 notices of confidentiality? It's because the media was after immediate access. And once that technology solution was given, they got their immediate access. So I'm still exercising to the best of our ability that at our local level, before I put it on our public court docket, we will have performed redaction. So that was the good news of them getting their own tech solution on the side, was that it didn't tie our hands anymore. You know, the rules being complied with, and I could still try to protect. But anyway, please just notice that. I don't know what to tell you. I mean, you know, 61 times somebody asked us to redact, we still ended up redacting 319 times. That's an awful lot of confidential information that did go out then. In that period from October 2023 through December 2023, those went out to that live site without redaction. This is just the redaction we performed at our level for our purposes, okay? So I just wanted to let you all know that to make it super clear. All right. So now we're where's the live site located? It is through the e-portal. David showed you a screenshot. It's called, what's it called again, that little tab? I know we weren't supposed to.
Let's see. It is the
Portal
filing access.
If here's a great question. I'm sorry. We were going to do Q&A, but this is such a good question. If a document gets kicked back in the correction queue, does it get removed from that live site? No. Because the rejection queue, the correction queue, where we deal with you and say, hey, there's a mistake here, I don't think you meant to file this, and we give you a chance to get that out of there or refile it or whatever, that happens at the local level with the clerk. If somebody filed something at Friday at midnight, it went straight to that live site. So even if later on we say, hey, you didn't mean to file this, too late. Okay, that's why I really want y'all to hear us and be much more careful. Okay. So, oh, was that really quick before we go into electronic rules package? Was that where I was going to show minimization real quick? Yes, really quick. We just wanted to tell you guys, because as we did this to prepare for this, we realized we found a very common mistake is what you guys aren't filing a notice on and what's going wrong that's getting out there. So one of the most common things we're redacting, even though you guys didn't notice it, is parts, either a whole social security number or parts of a social security number. One of the confusing things in Florida, why I want you guys to look at, wait, scroll back up to the top of that rule so they can see it. It's called the minimization of the filing of sensitive information. So there is literally a rule directing attorneys and filers, whoever assists you in filing. This is for all of you. Please read this rule. It tells you what should and should not ever be in a court record. Now that you don't have us as the safety net in civil, this becomes all that more important, okay? So if you follow this, there won't be anything in there that you have to worry about when it gets released live on that site. You don't have to worry the media is going to get something they shouldn't have because you followed this minimization rule. So if they're a minor, it's only supposed to be initials. Don't put a whole minor's name. The year of birth of a person's birth date, don't put the whole birth date. And then look at number 3. Here's the one we wanted to call to your attention. No portion of any social security number. No portion. So one of the main mistakes we find is failures to follow 2.425 we get because of the inclusion of the last 4 digits of the social security number. Because the minimization rule says it should have been no part of any social, when you include the last 4. Now, I know it's confusing because the feds, right? For federal purposes, they like the last 4, and last 4 is allowed in a lot of places. Not so in Florida. So even when you've only included the last 4, that's going to cause a redaction on the clerk's end. Okay, so please be aware of that rule and stop putting the last 4 numbers of the social security number, and that will help a lot. And we had a circuit court 51-page motion filed with his own client's last 4 of his social throughout all the copies of the subpoenas being referenced. So 51 pages of us combing through getting rid of that. Okay, now I'll be quiet and let Mr. AJ give you some highlights. And we're down to only 40 minutes left, so we're going to probably need to pick it up. So just take them to what highlights in the pending package.
Yeah, so just briefly on that minimization rule, there are exceptions to it, by the way. So if you scroll down further to the rule, look at that as well, because it does provide the exceptions. If you're filing, for example, a credit card, you need the account number. So, but the rules, right now there's a pending what they call the everything rule. So they're rewriting a lot of the rules in the RJA, well, the rules of general practice area. So if you look at here right now, it's currently in front of the Supreme Court. It's in the comment phase. But this rules are being changed to conform with the electronic practice that goes with using the electronic portal. So it just aligns with what we're actually currently doing. It does hone in on certain things. For example, it makes it clear that only 3 emails per attorney can be used. Also, if you scroll down, David, it makes the portal authority as the official website that where you're supposed to be filing these portal documents. We know we were using that, but it wasn't actually in the rule. So now that's being adopted. It talks about the computing and extending times. It clarifies that so you're able to meet your deadlines. There's a lot of changes that are happening. Like I said, we don't know what's going to happen because ultimately the Supreme Court has to give us a decision what they're going to change in the rule. The signatures and representations to the court, what you're actually representing when you're filing these documents to the portal. So there are a lot of changes. How you file the documents, as we know, there's a lot of we file using the portal, so therefore that takes care of the service part of it. But if someone is not on the portal, then you're supposed to do email. Unrepresented parties, that's another rule that just passed, where unrepresented parties have to designate an email address. And we have a form available on our website where they have to designate unless they ask for an exception, which there are exceptions. For example, if someone's in jail or they don't have access to internet, but for the most part, unrepresented parties have to now be designated an email address. Now, another important rule that I want to also discuss is what things the clerk can reject, what things can actually be put in the correction queue. That's on our next slide. So here it is. So right now there's this proposal whereby they're tying our hands because, like as Laura mentioned, we were able to reject certain things. If we saw, for example, that a case shouldn't be filed in our county because it had Flagler instead of Volusia, things of that nature, we were able to put in the correction queue, reach out to the attorney, say, hey, I don't think you're meaning to file this, so go ahead and take it back. Now we can't do that. Now it has a list here, which are 7 things that unless they're on the list, we have to receive the document. And those things are, for example, the case number is incorrect, the case style is incorrect or has the wrong case style, consists of multiple documents filed as one document, multi-page documents, is illegible, corrupt, is a proposed order, unless it's being filed using a notice of filing to preserve the record, is barred by a court order. So this is a list that we're gonna be using if this rule gets passed. By the way, if it gets passed, we're gonna be using this specific rule, and we're gonna only send these documents to the correction queue, and anything else that you file, we have to accept it. So if you file a wrong case in our county, guess what? we have to take it in, we have to collect your filing fee. So we're not gonna be able to transfer it on your behalf. You're gonna have to do the extra legwork to actually get it to the right court.
Okay. Okay. There's one thing around this that's really drawn a lot of questions in the chat feature. So it may be pretty important that we address. We're getting pretty close to our Q&A, but it's on this. I'm getting a lot of, if you guys look at the chat with me, we're getting a whole lot about, look, there's times when forms require things though, like social security number, date of birth, DL, even for children, because a party's paying child support. So what should we be doing? I filed a notice of sensitive information, but got a notice that it didn't fall within 2.420 motion. This is the sad part. At this time, now, if it's social security numbers, some big things like that, I'd file your notice of confidentiality with it. 2 reasons. Number one, even if not everything that you're trying to protect is covered in 2.420, if you file the notice of confidential information with your filing, it'll keep it from going to that live site where it's disclosed. Although a lot of this seems to be in family cases and those don't go to the live site. Remember, the live site is only, because they're aware there's a lot of this in family law cases. They know that. So the media did not prevail and well, they didn't really even seek it. The media just wanted civil. I don't know why that's the most interesting to them, but they really never pursued anything else. So it is only civil. So don't worry as much in your family cases because those are coming to us. However, you are best off to file a notice of confidential information to get as much automatically protected as you can by us. The problem they're having, AJ, is some of this stuff isn't in 2.420 that seems to them obviously should be, like the DL and the date of birth, right? Mm-hmm. So then they're getting notice back from us saying we can't protect everything you asked us to because it's not in 2.420. Unfortunately, I hate to say this to you guys because it sounds like so much heck to go through over something. But at this point, unless and until it gets included in 2.420, then yes, your actual only option to get anything protected besides the things that are in 2.420 is to do a full motion. Now we have sample kind of fill in the blank motion for this right on our website. So they're not difficult motions really, but at this point, if it's not covered in 2.420, it should be that you file a motion with it. What I've always, we've discussed on some of the calls when attorneys struggle with this too, I've always thought too is think through hard. Do you really need to include it? Like they say, use initials for a minor. Well, let's say there's a form. Could it not, like, let's say, well, because the child support unit, the DOR at the state level needed it. Well, then just give it to them. Why are you putting it in the court file? Or opposing counsel has a right to it. Could you just disclose, hey, we're going to send you all this personal information on the side as part of discovery or just to share it. But what I'm going to file in the court file is going to be a redacted version. Like, does the judge themselves really need to know the exact social security number and date of birth of a minor? Do they? So just think that through. Could you provide that information to opposing counsel, to state agencies, whatever, like you're supposed to? But when that copy of that affidavit or whatever goes into the court file, could you not have removed that stuff? We have had some people think that through and realize you don't really need to include all that in the actual court file. What do you think, AJ?
Yeah, and another thing also, because probably people are thinking, well, there's a lot of exceptions under 119, which, also has DLs and all those things. Yeah. But again, 119 does not affect court records. The court records is its own separate entity. So although it may be protected in 119, it's not going to be protected in 2.42 unless you file the motion. Yeah, but like I said, please do think through. Yes, you had to put a full social on some form submitting to a state agency or something, but if that same form needs to come into a case file, could you not redact that out before you file it? Provide it separately on the side to opposing counsel. So try to work your way around it that way is what I would do. Now, this one person had asked, if you've really messed up, is there any way to ever remove a document off the live site? I truly believe that is a dead no. Plus, I don't know if you guys know how the internet works with bots and things like this, but once something's gotten out on the internet, there is no taking it back. Is everybody aware of that? Once it's out, it's gone. There's people that grab that kind of data and make copies and they resell it and they've got side websites. You just can't stop the madness once it's out there. So it wouldn't do you much good to pull it back anyway. But anyway, no, you can't, but it only stays up there for 5 days. So it's not like that live site. You can't look who filed what 2 months ago. It's only 5 days worth of filings at any given time. Then I guess it just disappears into nowhere, David, and it should appear on a clerk's website somewhere. Right.
Okay, I'm trying to kind of wrap this up just because, okay, let me just kind of quickly go through this one. This is more about here in Volusia County. Anybody notice we changed e-filing where it got a little more complicated when you file a new suit? It's more like in other counties. I don't know how many multi-county practitioners we have or how many we're used to Volusia, but I just wanted to let you know, back when the e-filing portal was created and they said that all kinds of, every attorney had to file through this e-portal and that was their only way to electronically file, clerks were given a choice to go with either simple or versus complex e-filing. At the time, I was not the clerk, but I was influential. I was probably already the chief deputy, or was at least the legal counsel. I can't remember which. But whatever I was influential in it. So I'm not just trying to blame the last clerk. But we, and she specifically, did decide back then to go with simple e-filing. Because like I said, one of our goals is customer service. Clerk's job is to recognize what a document is and name it appropriately. If everybody calls a motion to compel 80 different things, how do you ever do an accurate court reporting on how many motions to compel were filed? We don't ask you to tell us how to docket it. Think about back in the paper days, you dropped it off. Did you put a sticky note that said, by the way, clerk, I need you to docket this under da-da-da, and I'm going to come at 2 p.m. and type in my own litigants? No, that's the clerk's job to make sure that information is accurately entered and that we've categorized each document appropriately and gotten it into the right case. That is our job, not your job, we felt. So we, back in the day, went with simple e-filing here in Volusia County, along with many other counties chose that, where you pretty much just use the e-portal as a fax machine, pretty much. You pick a general, hey, it's a motion. Here you go, clerk. Have a nice day. I hope you get it on the system quickly. And we were pretty quick and we got them on and we did our own thing. Unfortunately, what happened is, as the e-filing portal has gotten more and more attention, the judiciary, I'll make a long story short, the judiciary started to want to drive certain processes, mainly because of the civil case management rules that came out with general, streamline, and complex cases. They decided they wanted to start to drive some of the workflow of how these cases would go through the system at the portal level. Well, every time they'd go, oh, we'll be able to just designate that those that checkboxed X and those that filled in X would do X. We kept thinking, uh-oh, that won't work in Volusia and the other handful of us with simple e-filing because we're not requiring all that data. So we basically, for the court's own data reporting needs and for their automation needs, we got forced pretty much into get on board, go complex. So just recently, we did switch to complex e-filing. We also did it because without that data capturing entry up front, it's harder for us to automate things. We have a lot of automation inside our own system here, don't get me wrong, but without capturing that data, I can't auto create cases like some of the other counties were. And as many of you might have known, I didn't know this for a while. We didn't have good communication from some of the people involved in civil at the time, but we didn't know also it was such a pain in the butt for a lot of you civil practitioners, because in other counties, you entered the data and it generated your civil cover sheet for you. So you didn't need to file a separate one. But because we were simply filing, you still needed to file one. So I know we gave a lot of you heck holding off things saying, we need your civil cover sheet, we need your civil cover sheet. Well, now that you're on complex, you no longer need that. You enter so much data yourselves that now it generates your civil cover sheet for you. So we did it because of automation pressures. It will enable us, we'll talk about the next steps briefly. It will enable us to take further steps at some auto case creation that will have backup review. I'm never just going to allow court files to just be, any old willy-nilly thing. We will have quality control, but we will be able to automate and reduce staff. Like I said, with my budget issues, they just really want us to get more and more automated because we don't have the funding for humans. So David, do you want to explain really briefly just kind of next steps on automation?
Sure. Because of that extra data that's coming in now through complex e-filing, the plan, and this is already in progress, we're going to talk about our portfolio board and the way we do projects, but we are capturing that data. We are going to use that to automatically create the case once it's gone through portal review. I mean, there's still going to be a clerk reviewing the case in general. However, what will happen is once the clerk reviews it, the case number will be created, the division will be assigned. You'll be able to see the case on our website, for instance, immediately upon processing from the portal, instead of going through an extra person here at the clerk's office. And then our hope is, and then what we'll do is the new suits people will be shifted to, instead of manually data entering everything because we're getting it from the portal, they're more going to be about checking for corrections. documents and doing the docketing. We will not be starting with any kind of automatic docketing. We still have our redaction and review process that we want to continue doing. So while the case number and the text data of the litigant information will be on our website immediately, there still will be humans looking at the dockets and docketing the documents and the images that go with it. Our hope is that less employees will be needed for the new suits process, and they can be shifted to the subsequent filings, which of course, there's so many filings per case that come in after a case is created that we need to focus on.
Okay, great. So I hope I'm answering one. I wanted to give a suggestion to everybody that if you attorneys would get involved in the RPG, the whatever it is, RGPJA rules committee, that we could get more added to 2.420, because that whole situation where you have a UCCJEA affidavit that requires all this stuff, but then we can't protect it. What a mess. Why don't you advocate for that to get added to 2.420? Okay, so that's why I'm encouraging you all to get more involved in these rules committees. If you don't have time to monitor yourself, maybe a paralegal or a staff member could start going to that website and monitoring the rule pending and get involved. Okay, really quick, and we can wrap up this last section. It's going to leave us 25 minutes to finish the last one, but that's good. I think this one's more practical than our next step is a deeper dive into some of the bigger state issues. So it's probably better that we spent more time on part one. So common e-filing issues we experience. This is practical, especially any paralegals, those of you responsible for e-filing for your attorneys. Please listen in this section, okay? So one of the things that could help us are, these are the most common repeated mistakes we what we find as you guys e-file documents. Filing of extra civil cover sheets. Now, sometimes that's our fault because we required one for so long that people may be confused that now that you have complex e-filing, we don't need them. We don't need the civil cover sheet any longer, and you definitely don't need more than one. So I don't know why that happens, but I guess we get extra civil cover sheets. Also, wrong case numbers and/or parties. This happens a lot. So please, I think some of that's probably copy paste issues. You're using the same form motion you did from a prior case. So you're changing certain things and you forget to change the case number, or you forget to change the party names. So please be careful of your wrong case numbers and/or parties. Especially remember, AJ showed you those pending e-rules. It's going to limit what we can reject severely. So right now you might say, well, yay, because we get sick of how often you guys send us to the correction queue and you're always holding back our pleadings. But it helps you because we keep you in a lot of instances from filing things that are incorrect in the file. When those pending e-rules go through and we can only send correction queue very limited circumstances, you're going to have a lot of mistakes being pushed right through into the court file and our hands are tied. So please watch out for your case numbers and parties. Wrong and missing filing fees. Please, we just have so little staff. We're so overwhelmed. Please don't make us chase you around for filing fees. Please just pay the right amount up front. No signatures. Please don't forget to sign. It's as easy as S/ under the rules. Missing pages on documents. So you have a 20-page document, but 3 of them are just blank pages or just missing. Several documents being filed as one. You guys, when you go to do a court filing, you can't put your, if your motion for this, your, request for a hearing and your, motion for, your notice of confidential, you can't put it all as one scanned document because we can't, comes in as an image. So each individual pleading needs to be filed as its own separate filing so that it can be docketed separately. You see what I'm saying?
And that will still be in the rejection reasons. That is one of the main ones that
Oh, is it?
Yes.
Oh, good.
Yes.
Thank God.
Well, because the main problem is that the e-filing stamp that actually has your official when you filed it and that document ID only goes on the first page. So if you filed 2 documents as one, if we were to split it, where's your stamp? Where's your proof that it ever got filed on that second document?
Show that you filed whatever that first document was.
Correct. So that is still a rejectable one.
And, the court file needs to be usable. It needs to be where each line, hey, this is the motion. Now, this is their request for hearing. This is their notice of filing. You need to be able to see on that court docket for the court's use and for your own. So if I've got 5 documents, one giant PDF logged in as one thing, that's very confusing. It just does not work. So please don't put several documents in one giant PDF and e-file it. That will not work. Cases being filed in the wrong division, please be careful there. And then incomplete final disposition forms. Okay, so we get a lot of incomplete forms for some reason. So those are just some common ones we wanted to share with you. We are supposed to do a Q&A break here. We've been doing a lot of it as we go, but let's pause for just a minute. We don't have a whole lot of time left. We're down to 20 minutes left, but let me pause and see. Would anyone please raise your hand and we can unmute you. I think we have everybody on auto mute, don't we, to keep noise down?
They can unmute themselves, yeah.
Okay, and you can unmute yourselves. Yeah, but please raise your hand if we have not. We find when filing certain petitions unclear which fee to select. Okay, I can get that. Yeah, I mean, sometimes that can be unclear. You would think it'd be driven. I thought once they selected associated, it would give the associated fee, David. They're not having to freehand tell us how much they want to give us, are they?
The portal has some limitations. There are some things where there might be multiple fees that are appropriate for some of that, and that's actually something we can talk about with about standardization projects. You know, there are standardization projects at the portal happening where there may be some changes for us and for every clerk, as far as what documents, what case categories that are on the portal, and so we're probably going to have to be completely reviewing what fees are tied to it and how we assess some of those.
Okay, yeah, we did forget to mention that because we spent so much time in this last section on the e-portal and about e-filing, because that is the main technology conduit between yourselves as practitioners and the courts and us as clerks. So that's why it's dominating the conversation. We do want to warn you, there are standardization projects and other pretty significant changes going on about the portal. So please keep that in mind and spread the word. Like I said, remember, we do not control the statewide e-portal. I get that a lot. I'll get messages. I can't believe you changed X. I can't believe you don't have. It's a statewide e-portal, and they're getting ready to mandate to us exactly what docket codes need to be available, and it will have more auto associated fees, etc., like David's saying. Okay, so you will see some changes that may make life a little easier, but you'll need to get familiar with all the choices.
Well, and I was about to say, and there will also be changes because the judiciary's approach is that the filer is responsible for more. So there are actually going to be more data entry, just like complex e-filing.
Yep.
Even in subsequent filings, there will be more expected of the filer to enter at the portal so that it flows down to us.
Yeah, so I want you all to know that, because the changes as they evolve will, unfortunately, continually, the trend is to put more and more on the filer's responsibility. Clerks actually generally somewhat disagree with that, because you can end up cutting us out of roles of making sure things are appropriately titled, etc., so that reports are accurate. So it's a little scary for us. We'd rather still perform our jobs as much as possible to ensure great court files, but there is a lot more of that coming. Okay, there's a trend that the filer is the one responsible. They're going to make you guys start associating docket numbers. Like if you go to file a, notice of a court hearing on a motion you'd previously filed, you'll have to link it to the docket code of which motion that it. So you got some stuff coming for you, and it is going to unfortunately impact filers. Okay, any questions at all? Any raised hands? We'll go on to our last section and we'll get through this one more quickly. It is a little bit more of just an FYI. Okay, so I'm going to kind of speed up. We'll be talking a little bit about the Supreme Court's authority via the Florida Courts Technology Commission or admin order over tech, meaning, why all of a sudden, hey, the clerk really should be doing this or that. Why aren't they getting around to it? There's a whole bunch that hits us that we have to do, hoops to jump and changes to make and reporting requirements that really take a lot of our IT department's time. I have a full development shop here. We literally have developers and a program, a development manager. So we build our own systems. It's a pretty sophisticated team, and we get hijacked by other people's needs a lot. Okay, so security matrix is a big one. We might want to focus mainly on that. That's about what can or cannot be displayed on using technology. And the Supreme Court dictates that through administrative orders. So there are no ands, ifs, or buts about who can see what online. That is not my decision. When that first happened and the security matrix came into effect and it clamped down visibility to certain case types and docket codes, I got so many angry calls from attorneys thinking I had done it just to make their lives heck. This is Supreme Court handed down, guys. I promise you that. I liked it better before. It was easier, trust me. Case reporting requirements driving our technology. There's a giant reporting change. We used to all report under SRS. Now it's called UCR, much more difficult, and it has taken over the efforts of our IT department far and wide for years and years. Next, court changes driving tech. We have changes. Sometimes they just randomly make, like a change to the uniform case numbering system that made us have to jump in and program a bunch of changes unexpectedly. Then we'll talk about the statewide clerks, the statewide system, CCIS, and then local IT projects. I want to show you how we rank them. Okay, so let's go quickly to the next slide. I might even want to just kind of skip this. Let me just say about this one, guys. Since we're almost out of time, I want to get to what's most important for you guys. So on this one, I'm just saying, like we said about the RGPJA, that we really wish you all were more aware and involved. Here's another one. This commission's really powerful. Okay. It's commission and board. It's a standing permanent, I think, kind of committee that issued from the Supreme Court. When technology, it was mainly clerks driving it. Clerks were starting to put court records online. Back when online first started happening. In fact, you knew we were one of the first because we got clerk.org. Isn't that wild? So out of all the clerks in the universe, we got clerk.org. So in the very beginning, when tech was happening and digitization and sharing of documents online was happening, clerks started going, hot dog, this will be an easier way for people to access court files. And they started scanning and putting all the images online. They also started saying to the judges, it'd be so much easier. I wouldn't need as many people if I wasn't shuffling paper. Please use this online docket. So clerks started rushing it. And so the courts went, whoa, wait a minute, because sensitive information they feared was going to get out because all these documents, there were no rules around it. Nobody knew this was ever going to be possible. So at first they started two committees, the Access versus the Privacy Committee. Believe it or not, there was a committee called the Access Committee and then one called the Privacy Committee, kind of like the two opposing sides. And then through that whole mess, they realized, wait, there's way more going on with tech than we ever realized. We need an entire commission, a giant commission of big players. It has judges and chief judges and all kinds. I mean, this is an impressive group to guide all court-related technology from this day forth. And they sure did. I have been to almost every meeting since they ever formed. It's an incredible body, and they make major decisions to which I believe 90% of attorneys are completely unaware until all of a sudden it's on your front doorstep, okay? So I know we were going to talk more about it, but there's just the name of some of the subcommittees. David Isaacson and is on some of these subcommittees. So we advocate zealously. I almost never miss it. I'm not a member, but I just try to be a squeaky wheel. Okay. So there's a link when we send this out later. You could click the link and look at who these people are and what's going on with this committee. I encourage you to look at their minutes, look at their upcoming schedule. Make it a point, attend just one. Just watch what these people are talking about court records and how everything's going to work. You might want to hear it. Okay, so next slide. Let's go on past FCTC.
And I was just gonna say, I mean, FCTC, it is open to the public. I mean, especially it's 2 days every quarter. Thursdays are the actual days that the subcommittees meet, where basically the decisions are being made. Friday's kind of a recap, and the Thursday meetings are the ones that are open to public comment. If there are attorneys that attend, there's representation from the Florida bar. There's various other, it's not just judges and clerks. There's attorneys as well.
Yeah, they do have attorneys on there. It's just it's so few if you look at how many there are, and we don't have many others just come to comment or to submit, hey, we're concerned about this thing you guys are considering, because they do like first and second readings. Okay, so it's not too late. They could be talking about an idea that you're like, that's a train wreck, and you maybe could interject. You can write letters to the FCTC, you can write letters to the individual committees, you can ask to be heard. So anyway, please do check it out. Let's go into the matrix, and I'm going to let David take this over. We do get orders sometimes that order us to give access to certain parties and make us try to violate the matrix. I wish more of you were aware of the matrix. So this is about security. Go ahead, David.
So the matrix, this is the thing Laura was saying, that this wasn't her favorite thing when it came out. I actually like it because it is complex and it took over my life for a while. But this is a Supreme Court order. There's multiple pages of text, but ultimately the thing that matters to most of us when we're looking at it is the spreadsheet that goes with it. This is published from the Supreme Court based on FCTC recommendations. This grid shows, and this is just a part of it, they can't fit the whole thing on there, but this grid shows all the various columns are the different people trying to access data on the web, and the different rows are the different case types that have been defined. And you can see where those intersect. You've got various levels, anywhere from A through H. These are what determine who gets to see what. Attorneys of record, this is why in probate, for instance, probate attorneys see less than a civil attorney. And that's because that's what the Supreme Court told us to do. Which areas, which ones parties can access, various government agencies, things like that. And to Laura's point, the key is attorneys of record is just that. It is all attorneys that are representing somebody on the case. There's no exceptions for attorney, attorney for the plaintiff versus attorney for the defendant. So when we get an order, a motion and order from the judge saying, I want this attorney to have access to it, or an attorney that's not even representing somebody. We have gotten that before, please give this attorney access to this case. I'm sorry, I have no technological way to do that, because it's based on, is your bar number associated with as an attorney to a litigant on the case? If you're just an attorney out there that has nothing to do with the case, the system's automatically going to say, oh, they're just a subscriber. Column 5 says they don't have access to delinquency cases, So, I mean, there is not a lot we can do about it. This gets updated typically once a year. The Supreme Court will send out some updates for it. There is time. It is one of the committees. The Access Governance Board is one of the FCTC committees. There's actually a form you can fill out with OSCA if you do think there are changes that need to be made. Probate has actually been made more accessible just in the past, I think, year. And that's due to, any attorney, anybody at all, agencies can contact the AGB. It gets brought up between them. It gets brought up to the full FCTC, whether it's agreed, whether there's a legal reason why somebody should have access. You'll see all those statutory and rule references on the right-hand side. So they analyze all of that. When the matrix first started, it was only 10 columns, I believe.
And we're up to 15 now. 15
so,
different types of users, all, or categories of users, all with their own.
A good example, the public defender. When this first came out, the public defender did not have access. It was just overlooked and nobody thought about it. So they petitioned and said, hey, we need better access than what we have right now. So they petitioned. It went a few rounds going back and forth of what they should have access to, and a new matrix was born. And so every clerk has to update it every time.
And I hope you all can see the complexity of this, just seeing this. I want you to pay attention to the fact that those are just broad case categories. Circuit civil, that's gigantic. There's a zillion different types of cases in circuit civil. And so that has that rules all the way across the board for circuit civil. We also have to have security settings down to each and every docket code. You can't even see that. That would be hundreds, if not thousands of pages long if we had to differentiate all that. Okay. So this is really complicated behind the scenes. When he alluded to, that was a real life experience. We had an attorney, I don't know how, but talk a judge into the fact that I guess they had a common, one of the parties was also a party in another case, but this attorney didn't represent, I don't know. It was complicated, but the attorney had nothing to do with, and I think it was a juvenile dependency or delinquency, some very confidential case type. And they got an order saying, even though I'm not the attorney in that case, I have nothing to do with that case, just command the clerk to give me access to it. It doesn't work that way. I mean, it's not like we're trying to be rebellious. We literally cannot do that, okay? So we just keep in mind, systems are programmed around these rules. There's no such thing as a non-party, non-attorney, not representing anybody to all of a sudden be dropped into full access to a totally confidential case. That is not going to happen, okay? So we had to say, I'm so sorry, we are unable to comply with this order. We don't agree with it either. But
and it's one thing to provide access via a if we're told to provide a copy to somebody, okay, we can do that, but we just can't automatically override the online access.
Yes, that's it.
And if you ever wonder why some documents you're allowed to see, some documents it shows confidential, some you have to put in your email address for us to go through VOR. That is, you'll notice that VOR column on there. That is also decided by the security matrix, not by.
I wanted to mention that too. If you see a document, you're like, this is ridiculous. I have to wait for them to redact it first. I'm so and so. Trust me, if it says VOR on it, it's being driven by this. So does everybody grasp that? I just know that's probably frustrated the heck out of you guys for a long time. And I have gotten calls just really giving me heck about this darn matrix, but it is Supreme Court driven. We do advocate. I go to the AGB. Like I said, my commitment's always the broadest access possible. So every time somebody asks for further access, I try to argue on behalf of granting it where necessary. But if you do ask the Access Governance Board to add or give you more access through this, make sure to have your legal references ready, okay? They won't just give it willy-nilly. Okay, let's go on past that. Because we are down to the last 8 minutes here. Thank you all for the kind comments, by the way, about our service. That is our heart. Our motto is we love helping people. So I hope you find us a helpful organization always, even if we sometimes disagree. Okay, so UCR, I don't think we need to do a lot about this. We even talked amongst ourselves. This more affects us. We just wanted you to know where some of our time and resources go, because I have heard people say, well, why hadn't you already automated, and why aren't you guys all over this and that? You have no idea how complex some of the requirements are that take up our technology development time coming down from the courts for their needs. So like I said, we used to have a simple reporting system called SRS. We were used to it, but all the way back in 16, you can see AOSC 16, they started telling us, no, we want a whole different type of reporting, lots more data than we ever used to get. Now you need to capture this, this, and this. Let's change up how all of it works. And they published numerous specs. We were going to take you to the site. I don't think there's any reason to. And so we have been, I call it hijacked. We have been preoccupied by the development of the UCR project for years and years and years, and it is ongoing. It's still not even over. Okay, so that happens to us. UCN, it's going to UCN. Just really, I mean, just quickly, because I don't think it's a huge one for them either, but just quickly about the UCN, what happened?
So basically, since 1998, there was a Supreme Court order talking about using a standardized case numbering throughout the state. It was never mandated that we had to use it locally. It just was kind of, it was for state reporting. It was behind the scenes. Some counties use it as their primary case number, some do not. And if you work in multiple counties, you might actually recognize that that some counties use, but we never have. But behind the scenes, every case number turned into one of those for state reporting purposes. In 2023, OSCA decided that they only want to capture the first 14 as a unique number. The party, defendant, and branch location identifiers became extra information as far as they were concerned.
Dropped.
And unfortunately, what that meant, though, is that in the larger counties that have multiple court locations like us, Miami-Dade was hugely affected by this. They might, in Miami-Dade, for instance, you might have your first civil case of the year be, 2024-0001, and then there's a code at the end that signifies which of the courthouses. We were doing like CICI versus CIDL. They have 7 different courthouses that they were dealing with this. OSCA, the way that they were working with this came out of UCR, the way that they were pulling in that data, because they were only reading the first 14, they couldn't tell the difference between 7 different cases that had the same first 14 digits where that branch location was different. So they gave us until January 1st, 2024 to redo our case numbering throughout the state.
But how did ours change? Tell them ours went.
So locally, the big difference you would notice from your side is you may have noticed in the past, every Daytona case always started with a 3, for instance. You knew just looking at eyeballing the number, you didn't even have to look at the suffix. You could say, oh, it starts with a 3, therefore it's a City Island or a Justice Center case. If it starts with a 1, it's a DeLand case. Because we had to avoid that potential overlap if you were to take off the suffix, we had to go with a single sequential number system that the first case of the year is now 10,001, the next one's 10,002. Does not matter whether it's a DeLand or a Daytona case, they are all sharing a same sequence number. So it's not as obvious with, now you actually do need to look at the suffix to know if it's a Daytona or a DeLand case.
Yeah, and mainly what I wanted to paint with this is this caused a lot of changes. Think about all the programmatic things that hinged on our last 4 numbers that are the last numbers we used to be able to use, and they all of a sudden you can't use these anymore. So really ran around reprogramming everything. Real great effort, right? So I'm a little bitter about it. Okay, next slide. CCIS really quick. We are so down to the wire, and you guys still need your last slide to get your CLE numbers. So let me just say, CCIS, the reason I want you to know about this is a giant state thing that pulls or is receives, but it gets copies of and replicates all the different case filings through the whole state of Florida from all clerk systems. So this is a clerk driven, it has a statutory funding source. Our statewide association, FCCC, runs it. It is called CCIS. So it's exciting because you could look up and see what what cases your client has pending and all kinds of other, or you want to research somebody to be able to find cases all over the state. So doesn't that sound fun? Wouldn't you like access? Right now, it's limited to government access. The FCTC and many other parties have been pushing for the security matrix to be applied to that CCIS. Well, that's a long debate. But anyway, for it to be applied to CCIS and it be released to attorneys. It is in the works, okay? There's a lot of debate going on. It's been going on for years trying to push this out to attorneys. There's now a rumor it may end up being a value-added service that you'd actually have to pay a little bit for, but it may be worth it to you. If you're a multi-county practitioner, or you would have reason to want to be able to pull from more than just Volusia, you don't want to log into all kinds of different clerk sites, this thing would be the bomb, okay? So just Keep your eyes open. Remember, I said this. So if you see me post, oh my gosh, guys, CCIS is now open to attorneys, you are going to want to jump on that bandwagon and register so that you can see statewide case viewing. Next slide.
And I was just going to say, just so you know, you are already affected by CCIS, because while you cannot log into it, when you are on the portal and you use the My Cases to be able to view filings after the clerk's filed them, that's actually feeding from CCIS. So you already are getting some of the benefit of that.
Yeah, you already are being affected by CCS. You just don't know it. But if you could log in directly, it would be a game changer. So just really last, we won't go through this. I just wanted you all to know we get inundated. We have tons of projects. What'd you say the total number of projects pending?
We're at 98 just for clerk ones right now.
Okay, so just for clerk enhancements. Well, what do you mean clerk ones? I mean, does that include all the court requests that we're working on?
Because, well, no, these are anything that, well, if it's coming external from the court, it still is a clerk request. The reason I bring that up is we also maintain a system for services, which is drug court and pretrial, as well as some of the sheriff's office's systems for warrants and career criminal.
We are integrated with some of the county's other technology requirements. So we perform some of the services, but just court related then is what we'll call it. Just purely clerk and court related type changes. We're up to, like he said, almost 100 pending projects at any given time. We do rank them. I don't know if you guys can see, you probably can't see my mouse. If you kind of circle where the criteria are, we rank them in priority to make sure that we're not just having favorites. Okay, so I wanted you all to know it's a very thoughtful process. There's 6 categories of that we rank. So it doesn't have a mandatory deadline. If the court has said by January 1st, then that's going to get a 10. You see what I'm saying? So mandatory deadlines, whether it has an external benefit, meaning we know all the attorneys would be thrilled, they'd love this, then we're going to rank it high for external benefit to you. Does it have an internal cost benefit? If I made this change, can I reduce 4 employees? Hopefully not lay them off, but not fill 4 positions and thereby make my budget work. We've reduced over 100 positions since 2008, by the way, guys. So we're on a steep decline that never stops running. Okay, how big of an effort is it? So I just wanted you to see how we rank them. Is that our last slide? Let's go to the, okay. And then this was the Q&A, but we'll read your comments. Go to the last where they can get their numbers, please. All right, right at 10:30, here you go, guys. I'm glad we didn't give it to you first or you might have left us. Just kidding, you wouldn't do that. But anyway, here's your course approval number. Well, I wish I'd have looked at this and I would have realized the 1.5 hours, 1.5 general, 1.5 technology hours. I hope it was worth your while. It keeps, several people have asked, could they get the slideshow? And I would assume the organizers would be amenable to that. If we could send, we'll send that to the people that arranged this with us after, and they could share that however best is to share it. I'm really happy for anyone that will watch it because I hope it's going to be helpful to all of us. And let's see.
If anybody, Laura, if anybody has questions about 2.420 or about motions, feel free to reach out. I can help and answer any questions to the best of my ability. But I hope you guys were at least able to recognize that the rule exists and that there's things that need to be followed in that rule.
I did see one question real quick for those that can stay on. I know it's 10:31, but it says on a subject not covered yet, with the rising cost of postage, will the court accept electronic proof of service rather than copies of the green receipts because the receipts are lost in the mail, or just never sign a return, trying to keep costs down for clients? I had believed that already was acceptable. We get electronic proof of service from service providers. You're allowed to e-file proofs. So there's very little left in court files that actually needs to be the original touchable, actual copy.
What they may be referring, that gets a lot used in probate, in the probate practice, and I'm on the committee, so I believe that's something that's being looked at right now to eliminate the green filings and the actual service of documents. So that's pending.
It's hard. I mean, yeah, I guess they're talking about not having them at all. Because I was thinking they could definitely scan and file them. There's no requirement we get it at paper, but you're talking about where they haven't even gotten it. But
yes, there's a few exceptions still, I know, that have been worked out, but that's a perfect example of what goes through RGPJA.
Yep, there you go. So I gave you one example of why you should be at FCTC, advocate, but here's RPGJA again. That's right. The example there is, if you think there should be better access in the security matrix, that something is too tight, you have to appeal to the Access Governance Board of the FCTC. But for things like forms you guys commonly include that we won't redact for you, advocate at the RGPJA to get those added to 2.420.
And the
And
same
then-
with that postage, right?
And
That's
then
the
the
type
same
of
with
thing.
that.
Yep.
Yeah, you could advocate for it to be included, that's no longer, that could be electronically dealt with. So I hope you all found this interesting, that you will check out some of the links in our slideshow when we show it. And I'm praying for better, advocacy for and better budget for us, that we can better serve you. So we're actively working on increasing our budget, having had the same budget or less in over 10 years. So anyway, okay. Thank you everyone so much for attending. If anybody want to raise a hand, any urgent question, anybody want to ask anything before we hang up? Thank you again to the organizers. Thank you all so much for your acknowledgement of the service of our clerks. They really are a dedicated crew. So thank you so very much. Hope you enjoyed it. We certainly enjoy being here with you. Have a great day, everybody. Was there anything else the organizers needed to say? All right.
Nope, we're good. Thank you so much.
Great. Thank you. I hope you all found it interesting. Bye-bye.
Thank you. Bye.